isn't really a home for this doctrine. And other than that, I think you would just be engaging in some kind of federal common law policy making where Congress hasn't.
So is the position, oh, sorry, can I just finish this one? So is your position that the contract analogy applies, but none of the contract defenses work in this context?
Correct.
Okay, so when you're making this concession about, potential miscarriage of justice, et cetera, you're just kind of pulling that from the ether?
So there we're assuming that you are kind of going outside of contract doctrines and you are trying to find as some sort of policy or maybe constitutional backstop, some safety valve. The safety valve I proposed to Justice Kagan is the right one. But again, we do not think that that is the right way to go.
Well, why isn't Justice Gorsuch right then? I mean, are we supposed to march through every single available contract defense for the restatement and say, this is why this couldn't apply here. This is why that couldn't apply here?
Petitioner has come up with 4 potential defenses. None of them applies. I think that you can just categorically say.
As to his case, but
No. Categorically, when a subsequent sentence does not make an appeal waiver against public policy, it doesn't make it unconscionable, it doesn't make it a breach of the implied duty of good faith, it doesn't frustrate this shared purpose that goes to the essence of the bargain. Just categorically, those defenses all fail. If there are other defenses out there, it was on Petitioner to raise them, and he hasn't.
Is the
Justice Kagan.
Is the premise of your answers to Justice Barrett that this court has no power to establish rules intended to safeguard the integrity of the judiciary?
That is not our position, but the rules need to be lodged, I think, in some source of law. There's no congressional source of law. There's no really constitutional source of law, given that there is not a constitutional right to appeal. So I don't think it makes sense to say.
That was my question. In other words, you're saying that we have to point to a statute, we have to point to a particular constitutional provision to set some boundary lines on what judges can do in a task that is supremely a judicial one.
I think
that we can't just say, there are some things that judges can do that would be a miscarriage of justice, and we don't need to point to a statute to be able to create a rule that polices the judiciary to that extent.
I think particularly because we are in the world of federal criminal law and federal criminal procedure, which is highly regulated by Congress and the Rules Committee, that's an especially a dangerous place for this court to be making policy making, even though I understand that it's policy making about what judges should do. It's policy making about which court should be the last word on certain types of cases. And I think that really is the province of Congress and the Rules Committee. If you disagree with me and you are going down the road of a miscarriage of justice exception, again, we strongly urge the court to cabinet to the circumstances that really
well, whatever the miscarriage of justice exception says, whether it's less cabined, whether it's more cabined, you're saying that the only way that we can do that is by referring to contract law principles or by finding, which I don't think exists because people would have found it, some statute that allows us to do that.
Or constitutional principles, or I think you're maybe gesturing towards something to do with the supervisory powers of the courts or something like that. But this isn't really a good home for the supervisory powers because this isn't about supervising the conduct in their courtroom. This is really about making rules about when when a decision should be final, whether that's at the district court stage or the court of appeals stage. That's kind of bread and butter federal criminal procedure stuff that Congress deals with and the Rules Committee deals with.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Well, can't we say, to continue your colloquy with Justice Kagan, can we not say that a plea bargain has some attributes of a contract, but it's not like an ordinary contract? I don't know, even the amici supporting Mr. Hunter say, this is the Cato ACLU brief, Point 1B, plea bargaining is no ordinary contract negotiations. So we can adopt a principle that is informed by contract law without taking the position that you now seem to be taking, which is this is just like any other contract, and all of the contractual defenses that might be recognized are available here. I find your position really hard to understand. On the one hand, you say you don't want to be burdened with having to litigate a lot of appeals that are taken by defendants who's entered into an appeal waiver, and then you're happy to have judges decide what, don't you think that anything that, any objection that a defendant might have could be characterized as unconscionable? I mean, we occasionally see issues of unconscionability in cases involving arbitration, and boy, some state courts really go to town with the unconscionability argument. But you're happy to deal with all those.
I'm definitely happy to say why categorically appeal waivers are not unconscionable, if that's the question. If the question is whether there should be some other rule that informs the court, yes, I agree plea bargains are not perfectly like contracts, so the analogy doesn't hold in all respects, but you would have to say that there's a constitutional dimension. I mean, there would have to be sort of some source of law that is informing what rule the court makes if it's not a contract rule. And there's not really a constitutional principle at play here, and I'm not really sure another source of law. So no, I want to be clear. We've been litigating this case as a contract case because that's how Petitioner has brought this. If the court wants to say that there are aspects that are not like a contract and other rules should apply, it would just need to ground those rules, I think, in something. I'm happy to explain, though, why.
Okay, thanks.
Counsel, on the second question presented, there is a way of reading that transcript in which one could say the judge basically said, I'm going to impose the condition, come back to me later if you disagree. And then he mentions the right to appeal, that there was permission to appeal at least this condition. Why can't we read that colloquy as such?
Because the district court doesn't have authority to modify the parties' agreement, so.
Well, then that goes to the silence that was the government's position there. All right, what does that do to the ripeness question that Justice Barrett had? Presumably, you would argue at any point in time that the waiver applies, correct?
That depends on the language of the agreement. Here, this agreement doesn't bar Petitioner from seeking modification of the condition of supervised release, so he could do that. The Fifth Circuit has said that an appeal from the denial of modification is covered by a waiver if it's the type of agreement that, if the type of appeal that could have been brought from the beginning.
Isn't that the vicious circle you're putting this defendant in, isn't it?
I don't think we're putting the defendant in any circle. I think the defendant entered into an agreement, and this was the terms of the deal.
Tough luck, because the Fifth Circuit won't let you do it, so we should let you do it. We should let you.
It is possible, I think, under the terms of the Fifth Circuit's doc, if the type of appeal that he brought were more as applied and not the type of thing he really could have brought from the beginning, given that this appeal waiver doesn't cover appeals from modification, it could be allowed.
You admitted that it would be unconscionable to contract to have a racist judge decide the case, correct?
I admitted it would be against public policy to say my sentence will be decided on the basis of race.
But it's not, in fact, against public policy to have a racist judge sentence you.
Yes, it would be against public policy, but the question is whether the agreement is against public policy. And again, the agreement is not to have a racist sentence.
But that's what
the agreement is to have no appeal, and that the agreement to have no appeal is not against any public policy.
Even though it involves a breach of the duty of good faith dealing, which applies to third parties that you delegate contract rights to.
But a judge is not a delegee under the agreement.
You can't have it both ways. He is either a judge acting in conformity with the law, or he is a delegee subject to the good faith and fair dealing condition. You want to pick and choose defenses.
Not at all, Your Honor. He is a judge acting in good faith in the law, but a presumption of the entire appeal waiver is that the defendant might not think that the sentence he ultimately receives is unlawful. That is kind of the core premise.
But it's not a question of unlawful, because it's a question of whether he's violated statutory rights, whether he has used impermissible constitutional factors, whether he's violated statutory limitations, imposing restitution when the statute doesn't provide for it and the agreement doesn't contemplate it. He's acted outside the bounds of expectation.
The relevant expectation under contract doctrine, again, I'm assuming now we're in contract world. The relevant expectations are not the parties' expectations as to what sentencing outcome will occur. Contracts hold even when unforeseen and
I
unexpected
agree.
things
I
happen.
submit things
The
to
relevant expectation is how the parties expected their agreement would operate, whatever the absence.
So why isn't it, and going back to Justice Kagan's question, we all assume that judges will act lawfully? Not that they can't make errors in calculations, but that they'll act lawfully and not unconstitutionally.
We do assume that, but the premise of the agreement here is that both sides might not think that the judge has acted lawfully. And if the defendant thinks the judge hasn't acted lawfully, he can't appeal. That's kind of the whole premise of this agreement here. That is the
All right,
assumption.
okay, we're going around in the circle we started with.
Justice Kagan. Justice Gorsuch, anything further?
You agree that are just unenforceable. So, for example, you cannot prospectively waive your Title VII rights.
Correct. Yes. This is quite different, though. I mean, you can't prospectively waive your right to sue under Title VII, this court has said, because the right to sue is basically integral to the substantive policy of Title VII, but the right to appeal is not integral to the substantive policy of any constitutional amendment or statutory amendment or anything like that. And
Except
we know
for
that because
Congress
it didn't.
granted a right to appeal, just as it granted a right to pursue Title VII.
Waiving the right to appeal also isn't against the policy of the right to appeal, because that would just mean we could never have any statutory
Well, we
waivers.
didn't have appeal waivers until about 3 minutes ago. And
We also didn't have appeals for 100 years, respectfully.
Yeah, and
We didn't have sentencing
we also
appeals at
didn't
all.
have plea agreements before that, if you really want to go back, counsel. So I'm not sure that works for you. And then with respect to contract, in what you call contract world, you agree that at least in principle, a defendant would have contract defenses, correct?
Yes.
Okay, thank you.
Justice Kavanaugh.
See, I appreciate your having alternative arguments and a party having alternative arguments. I think that's helpful because you don't know where the 9 of us are going to go. But then it's important to for me to keep clear on what the alternatives are. Your first one's the contract, no exceptions. Okay, the lower courts have not gone that way, have rejected it. Assume I'm
Correct.
not going that way.
Sure.
Okay, just me.
Sure.
Okay, so first alternative out for me. On the second alternative, I think you raise a good point. What source of law are we doing? But all the lower courts have been doing it, right? All the courts of appeals. And I could be federal common law, could be supervisory power, but it's there. And I think I'm just taking that as a given.
Yeah,
That is
courts
the-
have done it. The way this has arisen is courts, in the early 2000s, late 90s, often confronted with this, would say, yes, these are okay, but of course we would never enforce it in XYZ circumstances without really explaining why. But yes, they
it's-
have said
there's
that, but they have said
At
that.
this point, I take your technical point, and maybe it's more than technical, where does that come from? But it's everywhere in the courts of appeals. My old court, every court, right? And it might be interpreting the federal criminal rule, it might be supervisory power, it might be federal common law, it might be going to what an appeal is in the statute, to Justice Gorsuch's point, but it's there. Then it's just, what are the exceptions, right? Okay.
Yes.
So if we're on that, it's just what are the exceptions and whether to identify a general miscarriage of justice or to list 3 or 4 and then to say they're not exclusive, correct?
Correct.
Okay.
Correct.
And there's a pretty good consensus of exceptions in most of the courts of appeals.
Correct. Correct. And the ones that we've articulated, I
Like
think,
in
track
other
the-
words, I think this is not so hard in the sense that there's a kind of defined list. What happened here is the list is shorter than what most of the courts of appeals have, correct?
If this court is going down that road, I think saying there's still a defined list, there's just, 2 more bullets on the list.
Exactly.
We can live with that
exactly.
as long as the last bullet isn't catch-all, know it when you see it, if it's sufficiently egregious, because that is a real problem for us. If the bullets are if you just say the Fifth Circuit has 1 too few bullets, 2 too few bullets, that makes sense. But again, we don't think there are any bullets that could capture Petitioner's
Well, in the
argument.
DC Circuit, we did have a bullet that said results in a miscarriage of justice, and I
Yeah.
don't remember the place falling apart.
So I do think that if this court were to announce a standard like that, we would see kind of a flood of that.
Okay.
And there has also at this point been kind of enough common law, I guess, built up around it, that courts have denied those miscarriages enough that defendants may raise them less. But if this court were to announce that standard, we think defendants would raise them a lot. And again, I'm not suggesting courts would find miscarriages of justice constantly, the opposite, but that's the very
But it's gonna
problem. I
come
mean, if
up.
we're looking for the needle in the haystack, but in every case we're being deprived the benefit of our bargain, that's the
And
problem.
the ultimate benefit is the resource, right?
Correct. I mean, we enter into 45,000
And
plea agreements
ultimately,
a
it's
year,
a judge
so.
protective thing too, because the judges are, I
Correct.
got all that. The amicus brief of the Association let's see, which one? The Association of Federal Defenders says if we are too strict on this, there are going to be fewer plea bargains, so the resource problem is actually going to be worse. Do you want to respond to that very quickly, because I'm using time?
I don't agree with that. I mean, the most common alternative to entering into a guilty plea pursuant to an agreement is not a trial. It's entering into a guilty plea without an agreement, where the United States gives no concessions and the defendant retains his right to appeal his sentence. That's, I think, kind of the most common alternative that we have now, and that's, I think, where things would get channeled. So I think we'll still have pleas, but those pleas will probably be less favorable to defendants because we're not giving the concessions.
Thank you.
Justice Barrett?
Counsel, would the government be amenable to having defense counsel insert qualifications on the right to appeal and bargaining for the kinds of exceptions that some of the courts of appeals currently allow?
Yes, I'm very glad you raised that point. Defendants are always free to do that. I mean, again, I want to be clear, it's a very important term to us. So in some cases we won't budge, and in many cases we won't budge, but it's case by case, it's district by district. And we do enter into plea agreements with carve-outs for constitutional claims, carve-outs that limit the appeal waiver to only certain guidelines ranges, all the rest. And we have, in the appropriate cases, entered into plea agreements with no sentencing appeal waiver at all. So it really is a matter of defendant choice here.
So you've emphasized that if we're going to do something other than the contract analogy, we have to find some source of law in which to ground it, and you've been pressed about supervisory power. I'm wondering whether, in addition to supervisory power, another rationale is that this isn't a pure contract agreement because it has to be accepted by a third party. The district judge has a role in the process. And hence, because the district judge has a role in the process, there have to be some parameters to what the district court does in that process. And so our supervisory power over, it's not just purely between the government and the defendant. So our supervisory power over the third party in that process is a source of law that can justify some of these exceptions.
I see that argument. I think that could make some sense. I mean, I want to be clear, it's often the same judge that approves the plea deal as the one who sentences. It's not necessarily, but if you're just sort of saying the district court, not specific judge, I see that point. And if that's how this court wants to ground a series of exceptions, I think that makes sense. I want to be clear, we have gone sort of hard on the contract doctrine here because that's how Petitioner briefed this case, but I'm not trying to suggest that this court lacks
But
powers.
you would prefer, I guess I'm still a little bit confused when I asked you that before, like, are you only talking about it in terms of contract because the petitioner did? You said no, you do think of it as a contract?
Because there's no constitutional right to appeal and because Petitioner
Yeah.
hasn't briefed it as a supervisory power or on this theory that you've suggested, we do think the most logical place would be if the avenue that you've suggested is the power to supervise the accepting of the plea. I mean, I think that could make some sense as an avenue to accept these carve-outs.
Okay, thanks.
Justice Jackson?
Just want to clarify one factual point that I thought you were exploring with Justice Barrett. Are appeal waivers required in every district across this country? Aren't there some places? My understanding was that this is not uniform.
So I mean, they're never required. It's a term of a
No, I understand, but
voluntary
aren't there districts in which the background principle is not to put an appeal waiver in plea agreements?
So I'm actually not sure if there are any U.S. Attorney's Office that have a stock plea agreement without an appeal waiver, but some are more willing to bargain to bargain it away than others.
All right, and one other thing. You have repeatedly honed in on the nature of the appeal waiver. You say an appeal waiver is an agreement to let the court be the final arbiter at sentencing. Is that what the government's position is?
Yes.
What I'm wondering is whether that same position would hold with respect to an agreement pertaining to the trial. So let me give you a hypothetical. Suppose we have a defendant who wants to go to trial, but he'd like to lessen his potential sentencing exposure in the event that he's found guilty. could he contract with the government to prospectively waive his right to appeal any and all trial errors? Errors, in other words, we're leaving it to the trial court to make all the calls with respect to evidence, et cetera, and I'm not going to, as a matter of contract, appeal any of those errors.
I'm not prepared to commit on all trial errors, but of course you can prospectively waive right to, for example, certain evidentiary objections.
Why wouldn't
That
you
was
commit? It's the
Mezzanato.
same principle.
That's-
If the idea is that we can contract around making the trial judge be the final arbiter, which is what I understood.
I see what you're saying. You're
say,
saying that there would just be no appeal like from the trial. Yes, I would think that would be okay.
and you would think that there
Again.
would be no public policy interest of the court or the public in ensuring that people get a fair trial.
Again, I'm really wary to get out ahead when we're talking about these trial issues, which are outside
No, I'm
the
not.
scope.
I'm not asking you to get out ahead. I'm testing your principle that I'm testing your principle that there is no problem with an agreement to prospectively appeal errors in a proceeding that will ultimately impact whether it's the trial or the sentencing. You've said the reason why that's not a problem at sentencing is because the parties can agree to make the sentencing judge the final arbiter. So if he makes a mistake or not, he believes that's the right answer and you're not going to appeal that. All I'm doing is transporting that same principle to the trial, and your concerns about it are precisely the concerns that I have with respect to the sentencing issue.
I just don't know if there are issues at trial that are not waivable due to some external public policy that doesn't apply at sentencing.
Not the issue, the ability to appeal it. That's the point you keep making with respect to the sentence. So regardless of how fundamental the error is, you say at sentencing, we can agree that the trial judge is going to make the final call, or the sentencing judge. And all I'm asking you is, couldn't you, under your logic, do the same thing with respect to trials? And wouldn't that be a problem from the standpoint of ensuring that people actually get a fair trial as a matter of public policy?
I don't think so, again, given that we didn't have the right to criminal appeals for 100 years.
Thank you.
Thank you, counsel. Rebuttal, Ms. Black?
Thank you. Number one, just some data points. 1992 was the first court of appeals that said defendants can't be deemed to have sentenced entirely at the whim of the discretion of the district court. So that's Fourth Circuit. 2009, DC Circuit was the last circuit to recognize exceptions. So all 11 circuits have weighed in, and I don't see the government running out of resources. In terms of authority, they're completely separate doctrines. One is the contract doctrine, and one is miscarriage of justice. In terms of the authority, it does, I think, come from an inherent equitable power. You could think of it as the government trying to seek specific performance. You could think of it as supervisory or inherent, or in terms of separation of powers. We're not going to let sentences bring the judiciary into disrepute. And this would, number two, all the cases that I mentioned were not hypotheticals. They were all real on pages in our reply brief and our opening brief about the castration, et cetera. The Fourth Circuit case cited by Cato is a case where the district court 20 times missentenced the defendant knowing his conduct would be shielded by the appeal waiver. So this is a concern. Number five, on remand, in terms of why we should get a remand. We haven't even briefed the unconstitutionality of this. The government says this is silly, but they've never asserted a justification for the mandatory medication condition. They've never even said why it's there. If they're really worried about resources, how about just confessing error and let the defendant just serve out his supervised release? It's not that complicated. Number five, in terms of the contract, how it is as a matter of law, not unconscionable or frustration of purpose. This is Hornbook contract law. Billions of contracts have open-ended terms, quantities, discretion of a party. Those are things that the parties don't yet know is going to happen. So this happens all the time. You have an open-ended contract. That's what an appeal waiver is. Also, I forgot counting how many times the government kept saying benefit of the bargain deal agreement. And all we're saying, it is beyond hypocritical to say the government is entitled to enforcement, yet and using contract law. They literally brief their cases using contract law. It is inconceivable and hypocritical and embarrassing to say a criminal defendant has no contract defense, at least when the government is seeking to enforce the contract. Thank you.
Thank you, counsel. The case is submitted.
This case is wild, folks. You guys heard that. If you didn't catch the beginning of this, I've got the documents. You can just Google it. The Supreme Court was listening to Hunter versus the U.S. And basically, wow, I'm just like, oh my gosh. So this case is wild, folks. This is like, you gotta be kidding me. So basically, it's like you asking your mother if you can get a cookie out of the cookie jar. And I put it in the chat, and it's like, your mom says you have to ask first. It's like you can't sneak in the kitchen, you can't yell from outside or go to the neighbor's house asking for one. You must follow the rule, and that's what the Supreme Court told Hunter. So it's crazy. It's crazy. So basically, in a nutshell, I put all the links. So he got in trouble, okay? And this case will clarify when defendants who sign appeal waivers in plea agreements can still challenge their sentences. Okay, and this was signed and granted on October 10th, 2025. They just heard it like you heard right now. The case addresses a circuit split that has confused practitioners for years. What happens when a sentencing judge tells a defendant he has the right to appeal, even though the defendant signed a waiver giving up that right? Well, what happened to Munson Hunter is he pled guilty in a federal court in Texas to aiding and abetting wire fraud. His plea agreement included a broader appeal waiver, a standard provision in federal plea deals that bars defendants from appealing their convictions or sentences except in narrow circumstances. And this is what they're doing. 3 months later at sentencing, the judge imposed a condition of supervising release requiring Hunter to take a medical health medications prescribed by his doctor. Hunter objected to this condition, arguing it violated his constitutional right to refuse unwanted medication. Despite the objection, the judge imposed the condition anyway, but then the judge told Hunter, you have a right to appeal. Hunter took the judge at his word and appealed to the Fifth Circuit, which we heard today, arguing the mandatory medication condition violated the liberty interest, recognizing a case, Sell v. United States. The government moved to dismiss, pointing to waiver appeal. The Circuit argued with the government and dismissed the appeal, holding the judge's statement at sentencing did not override the written waiver in the plea agreement. Wow. This is wild. This is crazy. So you can go and look at everything there. You can kind of see, and now the Supreme Court is obviously going to make the decision. And this is just wild. This is the case that I'm looking at right in front of us. Wow, I'm going to stay up to date on that. Let's rewatch it. We could watch it from the beginning, absolutely. Let's see if they have it back up there. Let me go and look. It'll have to be on the, hold on. Let me see if I can go back up there from the beginning. Oh yeah, I can. Let's rewatch
Appeal
it.
for sentences above statutory maximum based on race, religion, national origin, tribal status, or pure vindictiveness. No appeal for pregnancy bans, castration, or compelled church attendance either. These scenarios are all real cases. Or take this case. Only the most paramount government interest overcomes the fundamental right to refuse medical treatment. But Hunter was sentenced to a mandatory medical condition even though he had no mental health issues, let alone one connected to the crime or related to any sentencing goal. Defendants bargained for caps on their sentencing exposure. Those bargains are destroyed by plainly unlawful sentences that are totally outside the realm of plausibility of either party. Now, Floodgate's concerns are belied by decades of experience in the 11 circuits that reject the Fifth Circuit's rule. Applying defenses to appeal waivers maintains the status quo. Contract defenses are narrow by design and rarely satisfied. Appeal waivers will continue to bar the vast majority of alleged sentencing errors, guidelines miscalculations, insufficient explanation, or misbalancing under 3553A. But contract defenses may be satisfied in the rare case of clear legal error and punishment unauthorized by statute or that violates the Constitution. At a minimum, this court should remand on the second question presented. I welcome questions.
Ms. Blatt, if you can waive constitutional rights or statutory rights, why can't you waive these contractually rights that are statutory here?
You absolutely can waive the right to appeal, and there's a appeal agreement. But the issue here is absent this plea agreement, which is a contract, the defendant could just walk away. The only thing that is binding him to the waiver, and the government is asserting the enforceability of the appeal waiver by contract. I don't think there's any dispute that the plea agreement is a contract. If you waive your right to trial when you at the arraignment and just say, I waive my fundamental right to trial, that's a pretty big waiver. Tomorrow you can get up and say, you know what, Judge, I think I want a jury trial. You can just revoke it. But here there's a plea agreement, there's a contract. The government has to rely on the contract principles. The government gets out of plea agreements by relying on contract defenses, and there's just no rational, or it's just inexplicable that you would not apply contract defenses to this contract when you do to all others.
In this case, could the government simply void the agreement and proceed with the 10 counts?
Yeah, I don't think so, but here's why. The government has, in many cases, asserted frustration of purpose and did exactly what you said. I think here, because the government has no interest and is not defending the mandatory medication condition, there's just no countervailing principles. Now, the government has not disputed it can allege a breach of the plea agreement, and that would result in an invalidation of the plea. The government just doesn't dispute that. That's why defendants so rarely bring these appeals, is because they run a substantial risk of exactly what you're saying.
Yeah, but if they are saying, wait a minute, I didn't agree to this. This was not a stipulation of my my plea deal, my plea arrangement, my contract. This is like after the fact. Now, is the court, the highest court in our country, going to therefore say, now you must take your medication if it's part of the plea deal, which clearly this was not? That is, now they're trying to change the rules in the process of playing a game. That's what I'm trying to say clearly. Let's say that you got in trouble, you took a plea deal. Okay, none of this was specified in the plea deal at the time. So now he's getting ready for release, and they say, well, wait a minute, you've been diagnosed with XYZ and you need to be on medication, and that will be part of your release. And now they are saying, because of this is part of your release, you have to be forced to take this medication. And he's saying, wait a minute, that's not what I agreed on at the time of the plea deal. That's what I understand. Now, I could be wrong, but I'm just saying, I think we all just heard what they were arguing about and what they were clearly defending. When do we draw the line and say, no, somebody, you can't get out of prison unless you take your medication? Obviously, he's standing up for his right, saying, no, I'm not going to put that stuff in my body, and I don't agree to this. Phoenix, how does this apply to the state versus Brian? You know, that's a good question. I don't know. I am not a legal expert. I'm not a lawyer. I'm not a legal scholar. All I know, if this was me and I was forced into a plea deal, okay? I mean, if you look at the defense, they held out for a long time wanting a trial. They wanted to gather more information. They wanted to poke holes in the prosecution's case. And they held out for a long time. Now, the data is a large amount of data. Okay, we all know and benchmark how much data they got. But remember, part of that data could also be a lot of video. A lot of video takes hours to watch through, to look through, to pick up things. I mean, we're still watching videos and picking up things. Think about, I think, 3 people trying to go through all that data they were given. Now, how does this apply to the state versus Brian? Well, I mean, he does have the right to file a post-conviction relief. And in that, he does have the ability to say he had ineffective counsel, even though at the time, his frame of mind, I mean, if you think about what was your frame of mind at the time you signed this? Well, I was facing the death penalty. I didn't want to die. Is that a justification to say my attorney was incompetent? Maybe. I mean, Anne did stand there and hesitate to answer the question when she was asked. I mean, they would look like they were both forced to do what they needed to do. I don't think anyone would disagree with that after watching that video as many times as we watched. So what would be his strategy? I would say a post-conviction relief. And I would actually ask for a jury trial. He never got one. So can't he still have one? That's a great question for a legal scholar. Can he still have a trial? If he said right now, I want post-conviction relief and I want a trial, could he do that? That's the question we should be asking. Even though he has not filed anything yet, let me ask. He can ask for post-conviction relief and a jury trial. Yes, before conviction, but he's already had conviction. Not before conviction. PCR is available before conviction, after sentencing, usually after direct appeals are exhausted, but he waived the right to appeal. So I don't know. We would have to ask an expert scholar in appeals. And remember, Elizabeth, I think Miss Mastoff is an expert at appeals, isn't she? Let me look at her bio again. Hold on. Let me see. I think she is an appellate attorney. I think she might be. I think she is, guys. Let me just take a look real quick. I think she is. Let me see. I believe yes. I don't see why not. I'm sure she's following this very closely. You know, there's questions that I have every single day about this case. Like, why didn't it go this way? Why didn't they take the chance? And I understand that Ann Taylor didn't want to bargain with his life. I get that. Nobody wants to spend, ask Grok. Nobody, I don't like AI, but in this case, granted, accepted, is a plea considered a conviction? Well, he took the plea deal and he was legally convicted. They put him and they sentenced him. That is a conviction. So yes, he legally was convicted. Legally. Now he can appeal that conviction, or, I mean, I believe so. Looking at the process, due process, he was legally convicted, sentenced to life in prison without the possibility of parole. And that is a great question, Caleb. I'm going to look into that. There's got to be more Like I said, there's gonna always be more to this. It's an agreement. They mentioned a contract. They mentioned a contract, but what does that contract entail? We've seen the plea agreement. He signed it. That's the contract. So we'd have to go back and look at the plea agreement. It is a binding written contract. It spared him from the death penalty. Let me look. We saw the plea deal. Wild. Here it is. Let me see. Plea agreement. State of Idaho. Let me see if we can all see this. Here it is. Here's the plea agreement. The defendant will enter guilty pleas, sentenced to 10 years for fixed 1 and fixed life sentences for 2 to 5. The defendant will, the state may seek restitution, which they did. Defendant understands the nature of the agree and is not being coerced into entering the plea of guilty, the consequences of pleading guilty, including, but you know what? And I don't want to say this, but can't he use the disability of autism in his frame of mind at this time? How do we know that they didn't give him testing to have him understand what he was doing? I'm sure they did, to cross their T's and dot their I's. The defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his own attorney all possible defenses, and by his plea of guilt voluntarily waives those defenses and all claims based upon his constitutional rights. I don't understand why somebody would sign this. I would say just go to trial and go the traditional route of appeals. Why would somebody even sign this? He never signed it. It's signed right there. That's his signature. It's right there. This is signed on the 30th day of June. Ann Taylor signed it. Jennings signed it. Koberger signed it. Why would somebody sign something like this? Why is somebody so intelligent, so focused on his criminology? Maybe we need counsel or an independent counsel for the counsel. Like if you were accused of this and you had attorneys, shouldn't there be an oversight, somebody else who oversees this to make sure you don't get railroaded by the state? He didn't sign something, I don't remember what it was. It was, I showed it. It was one of the protection orders he didn't sign. They must have overlooked it, but he never signed it. It's in the repository. Exactly, because he is terrified they're rats. I mean, think about it. You're going to give up your constitutional rights? I mean, I'm no legal scholar, but I would never waive defenses and all claims based upon my constitutional rights. That's like just giving them free will. That doesn't make sense to me at all. It smells ratty. Absolutely. The defendant understands that if they were to proceed to trial, he would have the right to appeal, but not limited to any issues decided by a court prior to the defendant's guilty plea, including any rulings of admissibility of evidence, the judgment, including the finding of guilt of any issues regarding the guilty plea, and the sentence. That's it. That's signing your rights away too. Furthermore, the defendant understands that if he were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of sentence. He could have, even if they found him guilty, he could have had filed a reduction of sentence. The defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. Why would somebody so intelligent, so knowledgeable, sign something like this? That doesn't make sense. That covered the loophole right there. He signed this plea, this binding contract, this plea agreement to sit in a jail cell for life with no legal recourse. No, it's like sit down, shut up, and don't talk back. That's what it is. That is the lawyer's job, but he was trusting the lawyers to figure this out. And as many times as Anne said in front of Judge Hippler, and she even put it on paper, it was very difficult to work with her client. She said that in writing. I've seen it in the court documents. I'm going to find it. This contract, or it ain't legally certified, but this contract, or it was doctored. Well, let me take a look at it. Doesn't the judge have to sign off on a plea agreement? This is the entered plea agreement and stipulated to the following plea agreement. This was the plea agreement. And the judge signed off on this. He entered it into the record and sentenced him. He accepted it. If the judge would have said, no, I'm not going to accept this plea agreement, the judge allowed this to happen. The judge being the third party, exactly what they were just talking about in what we were listening to. I'm going to go back to that because this is really super important as we finish listening to this. Listen to what they're about to say.
We would try to argue that there's no breach based on the fact that the judge told him he had a right to appeal. And even if it is a breach, you know, it's justified by defending the contract exception, and the government doesn't have any countervailing interest to invalidate the whole agreement. And that's all the stuff we would fight on remand. Here we're cut off because the Fifth Circuit has this categorical rule that although it's a contract and you're denied the benefit of the bargain with sentences that exceed the statutory maximum, it allows no other exceptions.
Counsel, it seems to me that you're really asking for an equivalent of a Miranda warning that somebody would have to give, the prosecutor, maybe even the judge, going through all the things that you're required to. What exactly, what are the elements of what they must, you must tell the defendant, so that you don't leave any, strings untied?
So there's a distinction between the first question presented and the second question presented. If the judge said absolutely nothing, we'd still be here on a contract offense. There's no warnings. It's just there's 30 years of, actually 34 years where this has been the law. We think in terms of the second question presented, all the judge has to say is that you may have a right to appeal. You should look at your plea agreement. That's it. There's no other warnings. There's no nothing. So that's the second question presented. But on the first question presented, we're just arguing the government is enforcing the plea waiver. We're saying it's subject to one of contract offenses or miscarriage of justice exception. So that's all to brief on remand. This has nothing to do with what a court would have to educate the defendant about.
Well, I think it does have to do with that, and it seems to me that the court is the only one that can do it. If you're the defense attorney, I don't know, you want to advise your client, of course, but if the judge says something that's not right, it seems to me that the lawyer's in a tough position because the judge has given them an opportunity to raise this after the fact, if you think, and so that would be odd, I think, for the lawyer to stand up and say, oh, Your Honor, remember, you've got to tell him that he can't do this or this, or otherwise it might not be valid.
So on the second question presented, we are literally arguing a straight litigation forfeiture waiver. All we're saying, this is on the second question presented, all courts hold what you just said, except for the Ninth Circuit. It doesn't matter what the judge says, except the Ninth Circuit. What we're just presented is when the judge said you have a right to appeal, given the back and forth on the medication condition, and when the prosecutor said, Your Honor, I believe, well, I know, that two things happened. One, the defendant detrimentally relied on that in bringing the appeal and exposed himself to a breach. And two, and I think the better argument is, had the prosecutor spoken up, we would not be wondering, had the court imposed this bizarre medication condition, thinking that there could be a right to appeal, and that's a simple remand.
Well,
But the more important question is the first question presented, where all 11 circuits, this has nothing to do with what a court would advise. You just sign a plea agreement and there are broad waivers and that's it. Defendants don't bring these because it's an alleged breach. You do have these rare exceptions where it can mean a contract offense or be a miscarriage of justice. The castration example, a pregnancy ban, the government's view, race, mandatory medication, that tough. That's it. You sign the appeal waiver. That's absurd when everyone from Elon Musk to billionaires to corporations to mom and pops can assert contract offenses. The government doesn't even tell you why this contract, unlike any other contract in the entire universe, can't have a defense.
Ms. Blood, I guess I'm trying to figure out what the nature of your argument is. You refer to contract offenses, then you say, or a miscarriage of justice exception. In the time you've been up there, you've said the question is whether it's outside the realm of plausibility. You've referred to constitutional violations. I mean, when is it that this would come into play in your view, more specifically?
So hopefully almost never, because courts don't do crazy things like
Well, but
here.
I'm asking for a standard.
Sure.
Like, what are we looking to?
The standard is that the easiest and the high level rule statement is it's subject to contract offenses.
Well, I don't, what is a
Now I'm
contract
gonna-
offense? Does that just mean it's against public policy, or
No, I'm
are you
gonna break
referring
that-
to other kinds of?
Break that down. There are hundreds of years of precedent on very narrow defenses that sound maybe in label broad, but once you take off that label, they all have a thumb on the scale, exceedingly thumb on the scale in favor of enforcement. That's why contract offenses are so rare. And if you go past the restatements, you start reading why they're never applied, including public policy. Public policy, as this court said in Rummery, the first public policy is enforcement of the contract. So you would have to have some really out there public policy that would outweigh that.
Is there anything other than public policy that you're talking about?
No,
when
I
you
think-
refer to contract offenses?
I think the one that makes, public policy is a good one because it's rooted in this court's case law. The one that makes the most sense is the one the government asserts, which is frustration of purpose. The government has gotten out of plea agreements in the two cases, both in the Fifth Circuit and the 10th Circuit, because they said it was frustrated when a defendant didn't do anything wrong, but just got out on collateral relief. So frustration of purpose, why I think it's the best, and that's why I got the standard of outside the realm of plausibility.
Well, Ms. Blatt, I think you've got a strong argument on something like miscarriage of justice or something that's shockingly improper, something that would capture the examples that you started out with, where the sentence is based on race or religion or something like that. I think you've got a strong argument on that. When you go further, then I get nervous because public policy is very broad. Plea agreements have some attributes of a contract, but they're not like ordinary contracts. And imposing the entire law of contracts here seems to me rather open.
Okay, then can you please say the entire law of contracts is not applied to the government? Because that's all they do is cite contract law and enforce these plea agreements. So make sure you write your decision that they're not enforceable either under contract principles, that the government can't rely on it. It's a double standard, including in the Fifth Circuit.
Well, what do you, in concrete terms, what do you think the law of contracts would say about a variety of issues that might be waived? How about constitutional venue?
I don't know what you mean by that.
Sixth Amendment venue.
So all I'm
The right
talking,
to be tried in the state or district where the offense occurred.
I mean, waiver, mezzanata, you have a million cases on waiver. In terms of this case involves no waiver of a trial right. This is involving a waiver of the right to appeal sentencing errors. And the courts have generally said miscarriage of justice, but at least 8 of them have said contract principles.
What about the Sixth Amendment right to a speedy trial?
Well, you have cases on all of this about how the waiver has to be knowing and voluntary, and then you have to decide if it's a personal right versus a public right.
What about the suppression of evidence under the Fourth Amendment or the Sixth Amendment?
So you waive all that when you waive your right to trial. A defendant can almost never get out of a plea agreement. You've held back in, I think, 72 under Brady that plea agreements are binding and they waive the right. The only way to get out of a plea agreement, you have cases on that. Loeffler, you actually have Supreme Court cases that say you can almost never get out of a plea agreement.
Ms. Blatt, I thought the only thing before us was waiver of sentencing errors,
Correct.
not anything else.
Correct, because you have a million cases saying defendants can't get out of plea agreements.
And on Justice Alito's point about whether these are ordinary contracts or not, if they're not, we might think about unconstitutional conditions doctrine in this area too. And I was a little surprised we didn't have more of that in the briefing before us. And I'm kind of curious why. I mean, as I understand it, the defendant here pleaded guilty to 1 count of fraud for $32,000. That was the only amount charged in the indictment. And then he wound up being sentenced for something like $500,000 worth of fraud and a whole bunch of other unindicted incidents. And it's not clear to me what benefit he got from his plea waiver, appeal waiver, I should say, that would be proportionate and have a nexus to that additional right foregone.
So let me just, and I think this captures Justice Alito, a lot of defendants are unhappy with their sentences, but when they're mostly guidelines, but when they're within the statutory maximum, courts have universally said, tough luck. That part of the appeal waiver is the assumption that the court will make ordinary errors in sentencing guidelines as long as you're sentenced within the statutory maximum. The government's view is you can sentence someone for 30 years for a misdemeanor, and there's no right to defense. Now, they want to try to rely on maybe something in the contract, but that contract provision doesn't say what the government says. So, or nor the Fifth Circuit. The Fifth Circuit,
With respect, Ms. Blatt, do I get an answer to my question about why we don't have an unconstitutional?
The sentence seemed, 51 months and all the fine. I don't think because we're just, yeah, the defendant's not happy with the sentence. Most defendants aren't, but they're within the statutory maximum. So I think that's the answer. The condition of probation, the condition of supervised release is the preposterous one that says you have to follow the recommendations.
Right. One might argue, though, that that's an unconstitutional condition to be required to give up a right of bodily integrity without a compelling showing by the government.
Or any showing.
Any showing.
It's just totally bizarre. The government doesn't defend it. I'm going to get this example out. If there was a law that was passed that said all judges must take antidepressants recommended by their physician, I think you would find it stupidly unconstitutional and
All right. Did you hear that? She challenged him. She basically said, if all judges were to sign a contract that said that if you were to take medications, you would have to abide by it. I think she got him. Now, I want to go back to his sentencing day real quick, now that we're talking about it. Somebody brought up a really good point. So let's listen again what he said on that day.
I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement. meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well.
Here's a question for the chat. Do you think plea agreements are constitutional? Do you think plea agreements are constitutional? You just heard the justices argue that there were no plea agreements 100 years ago. Do you think they are constitutional? I know Caleb would say no. I knew that. I do not believe plea agreements are constitutional. They're basically coming in and saying, you don't have any rights. You don't have any options. You are going up against the firing squad. And if you don't take this, then you're going to sit on death row until the firing squad comes to get you. I do not think plea agreements are constitutional. You either have a defense, go to trial, you're either guilty or not guilty. End of story. Why did they not go to trial? What was being hidden in the Idaho 4 case? Who in their right mind would sign this plea deal? I don't think Brian would have signed a plea deal. Knowing what we see in his, if you go to Justice for All, I have a picture of all his books right there on the main screen. This is what he was studying. Why would he take a plea deal? Why? Another weird thing in this freaking Idaho 4 case. Let the Lord sort them. The rise and fall of the death penalty. What in the world? Mass incarceration on trial. A trial by jury. Why the innocent plead guilty and the guilty go free. He's got the criminal procedure law practice book right there. He's got it right in the dead center of this picture. Yes, he wrote a paper on it. Yes. Why do you think he took this plea deal? It doesn't add up. Another thing in the Idaho 4 case that does not add up. And yet he's not filed anything. He's not spoken out. No interviews. Nothing. Just like they made him sign it and throw away the key and we'll never see him again. If you apply contract law to it, then they're definitely not legal. One side has a weapon to your head, essentially threatening greater harm if you don't sign. Yes, it makes sense to avoid the death penalty. It makes sense. But the prosecutors, even though they had all the evidence in front of them, they already knew in February there was no DNA. They couldn't place him at the crime scene. What did they have? I want to see the smoking gun. What did they have on him that they did not share publicly? What did they have? Not to admit guilt. What did they not want to come out in a public trial? They wanted it all hidden, obviously. As we go back and listen to this hearing, listen to what the judge says. He's already agreed to take the plea.
Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that? Yes. All right. Thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. All right. And Mr. Koberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated. All right. Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right. I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised anything in exchange for your plea?
I'm going to stop it right there. I'm going to rewind this for 1 second, and I'm going to play it slow.
Bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised to be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than...
What are we watching? What in the heck did I just watch? Hold on 1 second, guys. This is freaking wild. I always trust my gut. I'm just saying.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable.
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
Why did he not use that right? Wow. Why do you think he didn't use that right? I would have got my accusers that you saw me. You saw me seriously standing at your door. I would have used it to the law of the fullest for every subpoena possible.
Offensive.
I think we already have. I mean,
And it
we've
might
got
be
a very
medically, and it might be medically appropriate to take
50-year-old
antidepressants.
case.
It doesn't matter.
Is the problem that you couldn't really raise Justice Gorsuch's very significant point because there is this waiver? Like the unconstitutional condition, I think, is an argument that could be made in the context of an appeal when you were trying to say that the trial judge or the sentencing judge did something wrong.
Yes, and
But the problem is you have a waiver, so you never even get.
can't raise it.
that
That's what I was
issue.
trying to say to Justice Kagan. In the universe of reading all of these cases, the so first of all, defendants don't bring them because they don't want to get turned around and have the plea agreement breached. The lawyers don't want to bring them because they've been sanctioned. And third, the Court of Appeals don't want to see these cases because they have to deal with it. And that's why when you read them, they say this is going to be rarely applied. Please don't bring them. It has to be an extreme
Right.
case.
Well, it
Your
might be
issue-
rare, but usually, we have a standard. What are those rare cases? How do we identify them? And that's what I'm trying to
So-
figure out. Now, you said, well, you could have the statutory maximum, but the Fifth Circuit actually seems to agree with you. So on that one, you're in the same place as the Fifth Circuit. So what else? And how do we?
So let me ask you a question in the chat right now, since we were just looking at the plea hearing and the change of plea for Brian Koberger. So somebody brings up a really good, valid point to this when we listen to the Supreme Court hear oral arguments in regards to plea deals, plea contracts. So let me get this straight. Brian Koberger pleads guilty to avoid the death penalty. We've heard that all over the news. He pled guilty to avoid the death penalty. But he's sitting there saying, I did this, sentence me to life in prison. And with no possibility of any parole, no possibility of any recourse, no appeals. So now we can just give up our constitutional rights because they charge you and they back you in a corner with a plea deal. So why not go to trial? Did he not understand the evidence that they didn't have against him? Was he fully aware what the FBI reports say, what the courts say, what the DNA says? Is he fully aware of this? Where is the third party oversight of his public defender? Shouldn't they be audited, watched? It's a kangaroo court, folks. They are being hired by the same side that's charging them. Was Ann Taylor really looking out for Brian Koberger's best interest, knowing he had autism, knowing in the court records she's even been said that he was very difficult to work with? He fixated on one thing and one thing only. Now, with all the evidence that we've seen up to date, was there some miscommunication of evidence? Was he telling her, I didn't do this, I have an alibi, I wasn't there? What happened in the Idaho 4? Why would somebody give up their God-given rights that he knew that he had 100%? I don't know, Veronica. That's a great question. Because at that point, this case went to a global level. All eyes were on Idaho. I mean, look at all the countries that come in here watching as we still talk about this case. I think this case will be talked about for years before there's any resolution, if any. I mean, if they consider that plea agreement constitutional, we are all forked. We are all forked. If you ever get your back up against the wall, charged with a crime you didn't commit, stand firm in the faith of knowing you will have the day in court you deserve against your accusers, against whatever may be, and hope that you have a good defense and the truth comes out. Seriously. This case was never about, in my humble opinion, Brian Koberger. With the evidence that we've seen, the documents that we've seen, the video and the audio that we've seen, the parents' interviews, everything that we've seen so far, and I know of you guys, some of you guys are more crime junkies than I am. Listening to these oral arguments just makes me think of bigger pictures at play, obviously. Absolutely. And I worked with a newspaper reporter in regards to that case. I had so many women reach out to me after one video I put out on the TikTok streets. One after the other. I put them in touch with this reporter. I mean, the producer reached out to me and said, look, I'm doing a story. I need to talk with you. We talked on the phone. I vetted her. I knew who she was. I knew who she worked for. I went back, she's a senior producer, went back, looked at all her work, senior news reporter too. And yeah, I got the whole story. Boy, it's crazy. No, he was not aware of his defense team had their hands tied by the judge with restriction and gag orders in the beginning of this course. Started with the grand jury. Yep, absolutely. That was where his first right was overlooked. There was no first hearing. There was no initial hearing. There was no. The grand jury, they went around and did the grand jury. You're absolutely right. Absolutely right. For Taylor, I just think she really believed she couldn't win, and the best was to get a plea. Yeah, she wasn't gonna bargain with his life. Wow, you gave some good details. Yeah, I don't know if you ever saw that video on TikTok that I made in regards to the judge and what was going on there. And I haven't really followed up on that case because at the same time, I was following up on a 2A case in Ohio, where I was helping the family in that case. So, I think when you look at these cases, some of these become national cases for a reason. Some of them are small families that want to talk about it, but they're scared to. I want to remember what that, hold on a minute. It wasn't Even the Riley Strain case, boy, I'll tell you, the Riley Strain case, I saw so, oh shoot, what happened to my computer? Something is glitching. Hold on. In the Riley Strain case, there was some crazy stuff going on in that. And I was able to look at the video and see some nefarious things happening. So yeah. No, I don't have TikTok. I didn't see it. Okay, Veronica, let me see. Something was going on with the TikTok server. I don't know what's going on. Maybe they're having some issues. Let me see. I haven't been on it in a few days. I've been so busy preparing my 12:15 with you guys. But I got to get some stuff done. If you get a chance, I'll put the video up there that I did in regards to the judge and the sheriff on my YouTube. Not to mention BT admitting to have nothing on BK. Absolutely. Absolutely. After the fact, he took a plea deal. Then they said, nope. And then the Payne gets up there and the other guy, what is his name? Gilbertson. He gets up there and says, nope, we didn't have anything. No stalking, no nothing. I bet you they railroaded him, in my humble opinion. It just looks that way. Burnout because this case gotta go. I hear you. Okay, so I'm gonna be back at 12:15. You guys are not gonna believe what I have for you. It's just crazy. I'll see you then. Thanks for joining the live Supreme Court that heard the oral arguments. If you guys want to finish watching that on your own, I'll drop the link once again. This was just a really quick impromptu because I was listening and I was comparing. Phoenix is being spied on. Beware. I shot the sheriff, but I didn't kill the deputy. All right. Y'all take care. See you later. 12:15. Keep it real.